everyone, my name is Rachita Mathur, currently working as a legal intern at LEXIS. So today I will be discussing on a topic presumptions. Presumption is a rule which is being made by judge or court to draw inferences from a particular fact or evidence unless such inferences is said to be disproved. Now, there are total three types of presumption. First is presumption that is being based on fact. Second, presumption of law. Third one is mixed presumption. Section 4, which talks about may presume, shall presume, or which talks about conclusive proof. So, may presume is whenever it is being provided by the act that the court may presume a fact, it may either with regard to such fact as proved unless and until it is disproved or may be called for proof of it. In case of shall presume, where it is being directed by the act that the court shall presume a fact, it shall be with regard to such fact as proved unless and until it is disproved. Conclusive proof, when one fact is declared by the act to be conclusive proof of the another, it shall not allow the evidence to be given for the purpose of proving it. Section 111A, Section 113, Clause B, Section 113, Clause A, Section 114 and Section 114, Clause A. All these sections are being related to the sections of presumption. Section 111A, which talks about presumption in case of certain offences where a person is accused of having been committed an offence that is being specified under subsection 2. Any area that is being declared to be a disturbed area under any enactment for the time being in force and making such provision for the suppression of disorder, resortation, or the maintenance of public order, or any area which over a period of more than 1 month to be the extensive disturbance of the public place, and that such person had been at a place in such area at a time when the fireworks is being used at a form that a place to attack or to resist the members of any armed forces or forces being charged with the maintenance of public order acting discharge of their duties, it shall be presumed unless and until contrary is shown that such person has committed such offence. Such offence is being referred under subsection 1 as the following, namely an offence under subsection the offence under section 121 to section 123 of Indian Penal Code 1860. Criminal conspiracy or attempt to commit or abatement of offences under section 122 or section 123 of IPC. Section 113 Clause A, which talks about presumption as to abatement of suicide by a married woman. Now the question is whether the commission of suicide by a woman has been abated by the husband or the relatives of the husband. It is shown that she has committed suicide within a period of 7 years of a marriage, and that husband or the relatives of the husband are being subject to cruelty. The court may presume, having been regards to all the other circumstances of the case, that such suicide have been abated by the husband or by the relatives of the husband. Explanation of this section is cruelty shall have the same meaning as contained under section 498A of IPC. Section 113 Clause B, which talks about presumption as to dowry death, where the question arises whether a person has committed the dowry death of a woman and it is shown that soon before her death such woman has been subject to cruelty or harassment in connection with any demand for dowry, the court shall presume that such person has caused the dowry death. Now section 114, which talks about court may presume existing of certain facts. Here the court may presume the existence of certain facts which likely to have happened with regards to be held in the common course of nature of event, human conduct, public and private business in relation to the facts of particular case. Now, here are some illustrations of section 114. The first illustration is an exception to general rule that presumption does not arise until the prosecution establish ownership of article, commission of theft, recent possession, or possession must be exclusive. Second illustration talks about unworthy of credit unless he is corroborated in material particulars. Next illustration talks about bills of exchange accepted or endorsed, or if endorsed for a good consideration. Next illustration is presumption of existence from previous or subsequent existence or performance of judicial and official acts. Next illustration talks about commercial course of transaction business that was being followed by the parties, or presumption of marriage. Next illustration talks about presumption from withholding evidence. Next talks about refusal to answer. Next and the last illustration talks about documents in the hands of obligator. Section 114 clause A talks about presumption as to absence of consent in certain prosecution for rape. In prosecution of rape under clause A to clause N of subsection 2 of section 76 of IPC, where sexual intercourse by the accused is proved and the question arises whether it was being done with or without the consent of the woman, and where such woman proves that such an act was being done without her consent, the court in this case shall presume that she did not consent. And the explanation of this section is, in this section, sexual intercourse shall have the same meaning as any of the acts mentioned in clause A to D of section 375 of IPC 1860. Thank you.